guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, the state did respond to the Tommy Zeigler defense team's motion for the rehearing. They actually responded to that on 3/31. It was posted to the Orange County Clerk's website. But in everything going on, I haven't had a chance to go through it yet. So we're going to go through it together, which is how we all seem to do it anyway. So let me pull up the clerk's website and we will start to go through it. It is a 10-page response to the defense's motion for rehearing. So again, this was filed on 3/31. It looks like 2 p.m. was when the state of Florida filed their response. It says the state of Florida's response to defendant's motion for rehearing. The state of Florida responds to the defendant's motion for rehearing, hereinafter motion MTN, filed on March 23rd, 2026. For the reasons stated below, the defendant's motion should be denied. Relevant legal standard. The decision to grant or deny a motion for rehearing is within the discretionary function of the trial court, but the court is limited to grounds for which a motion for rehearing is allowed under the rules. Riviera v. State, Florida 2008, Arguelles v. Citizens Prop Insurance Corp., Florida 3rd DCA 2019. The purpose of a motion for rehearing is not to re-argue the merits of the case, dispute this court's findings, or preserve an issue for appeal. Florida R. Crim, 3.851 F7. See also Whipple v. State, 431 Southern 2D, 1011, 1013, Florida 2nd DCA, 1983. Noting that it is improper to use a motion for rehearing, quote, as a vehicle to re-argue the merits of the court's decision or to express displeasure with its judgment, unquote. Rather, the purpose of a rehearing motion is to 1. Call attention to an overlooked issue of fact or law, or 2. To raise an argument based on precedent or a statute not previously available prior to the court's ruling. Florida R. Crim P 3.851 F7. Zeigler moves for a rehearing on only the former grounds. Argument 1. The fact that Zeigler believes multiple perpetrators could have been involved in the murders does not mean this court overlooked any issues of fact. Most of Zeigler's motion is simply a plea for this court to accept his reading of the evidence because he believes in his speculative inferences. See motion at 529, 12 through 13. But the mere possibility that one could torture the evidence to infer what the defendant wishes is not grounds for granting the defendant a new trial. A trial court's fact-finding related to newly discovered evidence should be supported by competent, substantial evidence. Hurst v. State, Florida 2009. Quote, speculation is not competent, substantial evidence, unquote. And that's referencing Light Vidal versus Light Vidal, Florida 4th DCA 2022. Zeigler's foremost complaint is that this court did not endorse his speculation that multiple perpetrators could have committed the murders. Motion at 5 to 9. Zeigler briefly acknowledges that this court addressed his, quote, multiple perpetrators, unquote, argument, but faults this court for its brevity while arguing this court should have afforded a different weight to the evidence. See motion at 6. There's also a lot of footnotes here. So let me come up here real quick. It's a lot of footnotes they're referencing. The second one they're referencing is actually further up here. But let me start with the third one, because the third one kind of gets into some details here. And they're referencing that at the motion at 5 to 9. And that footnote is 3. Zeigler separately complains that everyone, including the Florida Supreme Court, has been misunderstanding his shape-shifting whodunit theory about Charles Mays. He's not saying Mr. Mays killed any of the victims, just that he was hanging out with the person or persons who killed the victims. Motion at 5 through 6. But see TT 2610 through 12, 3.851, motion at 16, EH 12, 27 through 30, 961 through 63, stating or at least heavily implying that Mays was actively involved in murdering Perry Edwards. Zeigler asserts the continuity of his new position because he has been using the indefinite article to describe Mays' involvement in the murders. A motion at 5. But if we are making clever semantic arguments, it must be noted that if Mays did not participate in the murder of any of the victims, then Zeigler cannot call him a perpetrator of the murders. See Perpetrator, Black's Law Dictionary, 12th edition, 2024, defining perpetrator as, quote, someone who commits a crime or offense, one who does something illegal or immoral, unquote. Well, they aren't saying that Charles Mays didn't kill anyone. I don't know where they got that from, but they're not saying that. So we're going to jump right back into the reading here after that footnote. Zeigler fails to acknowledge that even if he can read some of the evidence to support his ever-evolving inferences about multiple perpetrators, this court found another, more rational explanation given all the other evidence Zeigler has been ignoring during these post-conviction proceedings. See Order Denying Defendant's Post-Conviction Motion, hereinafter order, at 41 through 42. This court is free to decline to make a finding when it is not supported by competent substantial evidence. See generally Martinez versus Lobster Haven, LLC, Florida 2nd DCA 2021, explaining that a fact finder is entitled to accept or reject an expert's conclusion when there are equally reasonable inferences that can be derived from the evidence presented. This court has no obligation to write an exhaustive treatise on every nuisance of each inference Zeigler poisoned during these proceedings. See Florida R. Crim, P 3.851 F5F. See also Tansey versus State, 94 Southern 3D 482 489, Florida 2012. Finding a 9.5-page order entered after an evidentiary hearing contained, quote, sufficient findings of facts and reasoning for the trial court's denial of the claims raised. Zeigler's disagreements with this court's analysis do not merit a rehearing of these failed claims. 2. Zeigler is not entitled to a rehearing simply because he wishes to rehash other arguments that this court already addressed. Zeigler dedicates another significant portion of his motion to relitigating the credibility of the trial testimony from Felton Thomas and Edward Williams, motion at 9 through 12. But this court already addressed this issue when it found the jury heard these attacks and rejected them, order at 40 through 41. This court found that nothing in the DNA evidence changes that calculus. ID 4, and that's going to be the footnote 4 here. Let's read that real quick. If anything, the DNA testing further undermines Zeigler's speculation about Williams and Thomas Felton. See State of Florida's post-evidentiary hearing closing argument and memorandum of law herein states, closing at 44 through 45. Zeigler also makes an entirely new argument by referring to testing which was completed in 1976 for gunshot residue on the clothing Williams turned over to law enforcement. Motion at 5. And this is the footnote 5 here. The issue first appeared during the direct appeal. See brief for appellate at 23 through 24. Zeigler versus State, Florida 1981. He also raised it during his federal habeas proceedings, but failed to sway the district court. Zeigler versus Crosby, and that's referencing July 10th of 2000, pointing out that all the guns, save the Colt Lawman Mark III, had been wiped down, so the lack of gunshot residue on Williams' pants did little to call his testimony into question. But raising an issue for the first time in a motion for rehearing is improper twice over. Doorbell versus State, that's Florida 2008. Arguments must be raised in the written post-conviction motion to be consonable under Florida R. Crim, P 3.851, Dabbs versus State, Florida 4th DCA 2017. An issue not raised previously cannot be raised for the first time in a motion for rehearing. There is simply nothing substantial that this court overlooked regarding the credibility of Thomas and Williams' trial testimony. Zeigler also asserts that he presented undisputed evidence that the presence of Ziegler's spattered blood on his pants must mean he was beaten after he was shot, and that in turn proves that he did not shoot himself. Motion at 12:13. But both the state and the court addressed this argument. See state closing at 29. The claim is procedurally barred. 46. His claim contradicts his trial testimony. See also order at 38. Finding that the blood found on Ziegler's pants likely came from his actively bleeding wound, not a beating. Ziegler's complaints amount to nothing more than a disagreement with this court's findings. Zeigler summarily complains that this court mistakenly relied on Mr. McDonald's testimony about medium velocity impact spiders. Motion at 13. And then we have footnote 6 here. Footnote 6 is Mr. Eichenblum purports to have expertise in the field of bloodstain pattern analysis, but was ignorant of the updated terminology. That's evidentiary hearing 431 549, referring to multiple spatter stains as medium velocity spatters. Also compare EH 366 458 with EH 793 through 794. The term projection is preferred over the outdated term artificial gushing or arterial gushing or arterial spurting. All right, let's go back up here. Zeigler's quibble overreads this court's summary of the testimony and is also irrelevant. The updated terminology did not influence any of the conclusions that established Zeigler's guilt. Both the state and the defendant's experts concluded that the bloodstains on Zeigler's clothing are consistent with Zeigler's shooting and beating Charles Mays. EH 604 through 07, 834 through 35. The remainder of Zeigler's motion contains, to put it bluntly, misreadings of this court's order that are so obvious that they merit no further attention. But there is a point the state wishes to clarify. Zeigler seized on one sentence in this court's order to imply that both parties have endorsed the theory that the gunshots to each victim would have produced backspatter on the killer's clothing. Motion at 5, quoting order at 36. The state believes that its position was clear. None of the forensic evidence supports Zeigler's backspatter theory as it relates to Eunice Zeigler and Virginia Edwards, but there is some support for the theory with respect to the blood spattered onto the ground where Perry Edwards' body was found. See state's closing at 32 through 39. This court made the express finding that blood spatter, be it backspatter from a gunshot wound or spatter from the blunt force injuries from Perry Edwards, would likely have spattered onto the killer's clothing. See order at 29. Yet this court declined to make a similar finding as it relates to Eunice Zeigler and Virginia Edwards. Based on this omission and the paragraph from which Zeigler plucked this quotation, the state does not believe that this court meant to suggest that the state was endorsing Zeigler's backspatter theory. If the state had misread this court's order, it prays that this court corrects this misperception. Wow, that's not sarcastic or anything, is it? Conclusion. This court did not overlook any substantial facts or arguments in its order. Therefore, the state respectfully asks this court to exercise its discretion and deny a rehearing. And it's signed James Earthminer and Joshua Schno, the Assistant Attorney General, with the Certificate of Service per usual. Yeah, I feel like this was such a sarcastic response, in my opinion. I mean, they didn't even really go into details. It's just, obviously they're going to quote, all the other stuff, the evidentiary hearing, the trial and all that. But they're just saying, you're wrong, you're wrong, you're wrong. That's all they're saying here, as far as I'm concerned. I mean, their argument is that Ziegler's team is just throwing out, a bunch of bullshit. That's the bottom line. That's what they're saying. They're saying, oh, there's nothing to this, and they think that we agree with them on some of this stuff and we don't. So yeah, it's to me, this response was kind of a blah response, in my opinion. So, what do you guys think of the state's response? Obviously, the defense on the motion for rehearing, which we covered on the last video for Tommy's case, um, it was very clear. You know what what Tommy's looking for, and all the supporting evidence and what have you to that, and the state just, and it's not even 10 pages obviously because of the so it's like an 8 page, um oh, we don't agree, they don't have anything new, yada 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 yada. That's what I'm getting out of it. And they don't like that they have possibly at all, agreed with the backspatter theories, or, it's just, but again, it just read as kind of a, we don't agree and please deny their motion. I mean, that's what I got out of it. But, let me know you guys' thoughts that are following the case. I mean, I'm not saying that the judge is not going to obviously take this into account, because the judge is going to take every single bit of it into account. And if this is denied, obviously, you can go move up to the Supreme Court. So as much as all this time that Ziegler's team has fought tooth and nail, you know it is toward the end, but there's still some there's still some things that can be played or put out. But yeah, it's been disappointing that the evidentiary hearing, it didn't warrant more than just the judge going no. I mean, that's, to me, I was just still, it blows my mind that the DNA just sort of just got thrown to the wayside and they're like no, but again, please let me know your thoughts in the comments. And with that said, I hope you have a great rest of the day, and most of all, stay safe.